Greetings. I hope that you and your loved ones are in the best of health and in good cheer amid these trying times caused by the coronavirus pandemic. This video is created for the benefit of my second year JMC College of Law students to supplement the review in their first exam on the rules of criminal procedure. It is my sincerest hope that you will find this video helpful, beneficial, or at the very least, constructive. Also, before we proceed, it must be made clear that the discussions herein are not comprehensive. This is merely a review, and as such, I would only discuss the pertinent and material matters of the topics included in the first exam. Alright, with that, we begin. At the outset, it would be perhaps prudent to first define criminal procedure. What is criminal procedure? How do we define criminal procedure? Well, basically, criminal procedure is a proceeding whereby the state prosecutes a person for an act or omission punishable by substantive law. Black's Law Dictionary defines criminal procedure as a generic term to describe the network of laws and rules which governs the procedural administration of justice. Indeed, in the case of People v. Lacson, 400 SCRA 267 306, our Supreme Court had the opportunity to define criminal procedure as procedural law applied to criminal law which provides or regulates the steps by which one who committed a crime is to be punished. Now, let's have a brief distinction between criminal law and criminal procedure. Alright? Criminal law determines or identifies the conduct which constitutes a crime. It defines a crime in general and prescribes the punishment for said crimes. While on the other hand, criminal procedure lays down the processes or rules by which an offender or the accused is made to answer for the crimes he or she allegedly committed. Corollary thereto, criminal law confines itself to the definitions of crimes or offenses, the gravity or the type of punishment to be rendered, and in general, criminal law formulates liability for the transgressions of substantive criminal statutes. Criminal law, however, does not provide the process, the method, nor the rules by which the alleged offender is taken into custody, tried, and consequently final judgment is rendered. These methods and processes are supplied by the rules on criminal procedure. Now, we made mention earlier of a criminal proceeding. What is the nature of this criminal proceeding? It is adversarial and accusatorial in character class, as it involves generally two contending parties, the prosecution or the state, the people of the Philippines, and the defendant, the defense, or the accused. Alright? Now, how do we interpret the rules on criminal procedure? The latter, being part of the rules of court, are to be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action or proceeding. Alright? This is provided for by Section 6, Rule 1 of the Revised Rules of Court. Now, a question or a situation may be posed in your first exam or in the bar exam as to whether the rules on criminal procedure has retroactive effect. Now, this is answered by the Supreme Court in a katina of cases. In Buebo versus People, GR number 163938, March 28, 2008, People versus Reyes, GR number 153119, April 2004, among others. Now, what did the Supreme Court say in this case? The answer is yes. The answer is yes. The rules on criminal procedure may be given retroactive effect. Okay? The rules on criminal procedure is, although it is generally prospective in application, it may be given retroactive effect as long as it is favorable to the accused, who is also not a habitual delinquent. Alright, with that, we proceed with the foremost topic in criminal procedure, which is jurisdiction. Okay? Jurisdiction. Now, what is jurisdiction in general? Jurisdiction in general is the authority of the court to hear and decide cases. However, it should be noted that in order for the court to exercise jurisdiction over a criminal case, it must first acquire the following. Alright? Number 1, jurisdiction over the subject matter. Second, jurisdiction over the person of the accused. And lastly, jurisdiction over the venue or territorial jurisdiction. You must never forget, class, that venue in criminal cases is jurisdictional. This is very important because unlike in civil cases, where venue may be waived by the parties or subject to the will of the parties, venue in criminal cases cannot be the subject to the will of the parties, and it certainly cannot be waived. That is the importance of the statement that venue in criminal cases is jurisdictional. It cannot be waived. Alright? Now again, by way of review, in order for the court to have jurisdiction over a particular criminal case, it must have, first, jurisdiction over the subject matter, second, jurisdiction over the person of the accused, and third, jurisdiction over the venue or territorial jurisdiction. Now let us discuss these one by one. Right? Let's start with the first one. Jurisdiction over the subject matter. Now what is this? Jurisdiction over the subject matter. It is the authority of the court to hear and decide the case. Or otherwise stated, it means jurisdiction over the offense charged. Now, a question may be posed. How does the court acquire jurisdiction over the subject matter or jurisdiction over the offense charged? It is conferred by law. Cannot be conferred by the parties. Okay? Class, jurisdiction over the subject matter is conferred by law. Okay? And as such, jurisdiction cannot be fixed by the will of the parties, nor acquired through waiver, nor enlarged by the parties' omissions, nor conferred by acquiescence of the court, or by mere administrative policy of any trial court. Alright? Now, how do you determine which court has jurisdiction? What do you consult? Okay? Jurisdiction is determined by the allegations in the complaint or information. Right? That's clear, class, ha? It is conferred by law. Jurisdiction over the subject matter is conferred by law, and it is determined by the allegations in the complaint or information. You consult the complaint, the allegations in the complaint or the information. Alright, let's go to jurisdiction over the person, the accused. Okay? It is the authority of the court over the person charged. Now, how is it acquired? How does the court acquire jurisdiction over the person of the accused? It's acquired through several ways. The first one is the arrest of the accused. Okay? The accused is arrested and brought to the court. Second, consent of the accused. Third, waiver of objections, as when the accused enters his plea without questioning the court's jurisdiction over his person. Lastly, voluntary submission of the accused to the jurisdiction of the court. However, class, take note that there is no voluntary submission of the accused to the jurisdiction of the court where in cases of special appearance, precisely to challenge the jurisdiction of the court over his person. Right, class? Okay, that's clear. Now, how about territorial jurisdiction? Okay? What is this? It is jurisdiction of the trial court over the place of the commission of the offense charged. Okay? Again, the place of the commission of the offense charged determines the venue of the action in a criminal case and is an essential element of jurisdiction. Okay? There are several exceptions to this. We will discuss the venue in criminal cases in detail a little later. Okay. Now, in territorial jurisdiction, it must be noted that the offense should have been committed or any of its essential ingredients should have taken place within the territorial jurisdiction of the said court. Okay? Now, again, how do you determine which court has jurisdiction? Again, you consult the allegations in the complaint or information. Okay? Can you waive this? Can you waive territorial jurisdiction? No, you cannot. Why? Why? Because venue in criminal cases is jurisdictional. Alright. Let's proceed with some principles. Principles in jurisdiction. Okay? But one of these principles is the principle of adherence of jurisdiction or continuing jurisdiction of a trial court. As a general rule, once a court acquires jurisdiction over a controversy, it shall continue to exercise it until final determination of the case. Okay? It is not affected by a valid amendment of the information, subsequent legislation, vesting jurisdiction in another tribunal. By way of exception, when the subsequent legislation expressly so provides or is clearly intended to apply to actions pending before its enactment. Alright, let's go to the specific jurisdictions of criminal courts or the specific criminal jurisdiction of the trial courts. Okay, class, listen. I will give this as a bonus. You memorize the exclusive original jurisdiction over criminal cases of the Municipal Trial Court, the MTC, the METC, MCTC, the exclusive original jurisdiction over criminal cases of the Regional Trial Court, the RTC, the Sandigan Bayan. Okay? Those three, you memorize this. This will come out in the exam. Most definitely. I will provide this as a bonus. You memorize it. You memorize it. Alright? Now, what are these cases falling within the criminal jurisdiction? Exclusive original jurisdiction of the MTC. Okay? What are these criminal cases? First one is violation of a city or municipal ordinance committed within the territorial jurisdiction of the Municipal Trial Court, the Municipal Circuit Trial Court, etc. Second, offenses punishable with imprisonment not exceeding 6 years, class. Not exceeding 6 years. Meaning, if it is 6 years, jurisdiction, criminal jurisdiction is with the Municipal Trial Court. If it is 6 years and 1 day, it is with the RTC. Alright? Now, this is irrespective. It doesn't matter. Irrespective of the amount of the fine. Irrespective or regardless of the imposable or accessory penalties, including civil liability. Okay? Also, number 3, offenses involving damage to property through criminal negligence. Sa man nakabungkag kag property through your negligence. For example, nakabangga ka og sakyanan. Okay? And also, violations of traffic laws, rules, violations of the rental law, BP 22 cases, violation of municipal and city ordinances, as we described earlier. And also, the Municipal Trial Court has exclusive jurisdiction over, or special jurisdiction to decide applications for bail in the absence of RTC judges in the province or the city. Okay, now let's go to the Regional Trial Court. What criminal cases are under the exclusive original jurisdiction of the Regional Trial Court? Okay, number 1, the criminal and civil aspects of written defamation as provided in Article 360 of the Revised Penal Code. Criminal cases regarding Republic Act 9344. Okay, where there are no family courts. Violence against women and children in the absence of an RTC designated as a family court where the offense was committed. Violations of Dangerous Drugs Act. Okay, the RTC is appointed as a drugs court. Money laundering cases, except those committed by public officers and private persons in conspiracy with such public officers, as jurisdiction is vested with the Sandigan Bayan. Okay? And also, of course, criminal cases or offenses with penalties above 6 years. Okay? Now let's go to the criminal cases under the exclusive original jurisdiction of the Sandigan Bayan. Now what are these? Violations of RA 3019, the Anti-Graft, Corrupt and Practices Act. Violations of Republic Act 1379. Violations of Book 2, Title 7, Section 2, Chapter 2 of the Revised Penal Code, the indirect bribery, corruption of public officials, etc. Where one or more of the accused are officials occupying the following positions in the government at the time the commission of the offense. Again, you have to remember, class, that in violations of Book 2, Title 7, Section 2, Chapter 2 of the Revised Penal Code, the accused are officials occupying the following positions in the government at the time of the commission of the offense. First, officials of the executive branch, occupying the positions of regional director and or higher, otherwise classified as grade 27 or higher. Again, officials with grade 27 or higher. Members of Congress or the legislative department and officials thereof, classified again as grade 27 or higher. Other offenses, simple or complex, with other crimes committed by the above-mentioned public officials and employees in relation to their office, and criminal cases filed pursuant to and in connection with EO1, EO1, EO2, EO14, and EO14A. However, class, you must remember that in those enumerations that officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27, napa na siya'y padayon, class. Okay? That provision, napa na'y padayon. Okay? Specifically, including the following public officers: provincial governors, vice governors, members of the Sangguniang Panlalawigan, and provincial treasurers, assessors, engineers, and other provincial department heads. They're specifically included in the enumeration, even if they are not within the salary grade 27 and above enumeration. Okay? They are specifically included. Who else are specifically included even though they do not have salary grade 27? Okay? They are not included in salary grade 27. Okay? Who are these public officials? City mayors, vice mayors, members of the Sangguniang Panglungsod, city treasurers, assessors, engineers, and other city department heads, even if they are not within the salary grade 27 enumeration. Okay? Who else? Officials of the diplomatic service, occupying the position of consul and higher, Philippine Army and Air Force colonels, naval captains, and all officers of higher rank, officers of the Philippine National Police, occupying the position of provincial director, and those holding the rank of senior superintendent or higher, city and provincial prosecutors and their assistants, and officials and prosecutors in the office of the ombudsman and special prosecutors. Again, even though they are not classified as having salary grade 27, presidents, directors, or trustees or managers of government-owned and controlled corporations, state universities, or educational institutions or foundations. Again, even though they are not classified as salary grade 27. Alright? Alright? Question. Is it absolutely required that the public officers being charged have a salary grade of 27? in order for the Sandigan Bayan to exercise jurisdiction over them? The answer is no. In a plethora of cases, the Supreme Court has held that the law is clear. Those persons specifically enumerated need not have a salary grade of 27 in order to be under the jurisdiction of the Sandigan Bayan. Again, by way of review, who are those accused under the jurisdiction of the Sandigan Bayan? First, they must be public officers in the exercise of their official functions. Second, the crimes are those that are enumerated under the law, or that the crime was committed in relation to their office. Third, the said public officers have a salary grade of 27, or by way of exceptions, those public officers or employees specifically mentioned in the law, even though their respective salary grade is under 27, as I have mentioned earlier. Now, what is the important requirement here? The crucial requirement here. And this is what is being frequently asked in the bar. Is the requirement of the offenses, or is the requirement that the offenses must be in relation to public office? The offense must be in relation to public office. Now, what does this mean exactly? So many. As a general rule, an offense is committed in relation to the office if the relation is such that, in the legal sense, the offense cannot exist without the office. Otherwise stated, the office must be a constituent element of the crime as defined by statute. Right? By way of example, the provisions of the Revised Penal Code, which specifically states crimes committed by public officers, malversation, frauds against the public treasury, direct bribery, failure to render an accounting, etc. Okay? These are the crimes where the office must be a constituent element of the crime as defined by statute. However, this is, in my opinion, a very restrictive definition, which is precisely why the Supreme Court, in a plethora of cases, ruled that even if the public office or position is not a constituent element of the crime or offense, if the offense is intimately related to the public office. You write this one down, class. You write this one down. Intimately connected to the public office. The offense is intimately connected to the public office. While the public officer was in the performance of his public functions, then the crime is in relation to the public office. Now, take note, class. The crime is intimately connected with the office, and the officer was in the performance of his official functions, such that the crime could not have been committed had he or she not held office. Okay? Again, the crime is intimately connected with the office, and the officer was in the performance of his official functions, such that the crime could not have been committed had he or she not held office. Okay? Now, by way of example, in one case, the offense was, I think, acts of lasciviousness, and the public officer was a judge. Okay? Clearly, being a judge is not a constituent element of acts of lasciviousness. Okay? As this can be committed by a private person, not necessarily a public officer. However, the Supreme Court ruled here that upon the facts proven, there is intimate connection with the crime of acts of lasciviousness and the public office of a judge. Now, what happened here? There was a female casual employee, and if I remember correctly, the recommendation of the judge was necessary for the appointment of the casual employee. However, the public officer imposed the condition that for such a recommendation to be given, that the casual employee become the public officer's girlfriend. And she has to kiss him every day. Alright, class? There is clear intimate connection here, because the crime could not have been committed in this particular case without the office. Why? Because the public officer was the recommending officer. Okay? Alright? We proceed with the next query. Question. Is there an instance where the Sandigan Bayan may exercise jurisdiction over private citizens? What is the answer? The answer is yes. Yes. If these private citizens are charged in conspiracy with public officers under the jurisdiction of the Sandigan Bayan. Okay, correlative question. A question in relation to that. What if the public officer dies during the pendency of the case? Or prior to the filing of the case? What if the public officer dies? Would the criminal liability of the co-conspirator private citizen become extinguished by the public officer's death? The answer is no. The answer is no. The death of the public officer did not extinguish the crime, nor did it remove the basis for the charge of the conspiracy. The private citizen may be charged independently of the public officer. Okay? That's clear, class? That is clear. Now, if such a situation exists where the public officer can no longer be charged, then the private citizen may be charged solitarily. Alright? Let's proceed to prosecution of offenses. Question. How is a criminal case or a criminal action instituted? Okay? The answer to this question calls for a distinction. You have to distinguish whether the criminal action requires a preliminary investigation or not. Now, what are these offenses which require preliminary investigation? Okay? These are offenses where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. If it is at least 4 to 1, then preliminary investigation is required. If it is less than 4 years, 2 months, and 1 day, less than 4 to 1, then preliminary investigation is required. Now, how do you institute criminal cases whose penalty is at least 4 years, 2 months, and 1 day? How do you institute it? You institute it by filing the complaint, the affidavit complaint, with the appropriate officer for the conduct of preliminary investigation. On the other hand, how do you institute criminal actions which do not require preliminary investigation? Okay, first, you file it directly with the municipal trial courts or the municipal circuit trial courts, or file it with the office of the prosecutor. However, you have to remember, class, that in Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their respective charters. Okay. Question, class. If you can remember, diba? Crimes have a prescriptive period. Now, what is the effect on these prescriptive periods on the filing of the criminal action? Okay? The institution of a criminal action shall interrupt the running of the prescriptive period of the offense charged unless otherwise provided under special laws. Okay? Also, while the dispute is under mediation, conciliation, or arbitration, either with the punong barangay or etc., the prescriptive period shall likewise be interrupted upon the filing of the complaint with the punong barangay. Okay? However, in this regard, the interruption shall not exceed 60 days from filing of complaint with the punong barangay as provided in the Local Government Code, Section 410, Paragraph C. Okay. Now, since we mentioned the punong barangay, the lupon, what are these criminal cases required to be filed with the lupon? These are offenses punishable by imprisonment not exceeding 1 year or a fine not exceeding 5,000 pesos, and where the parties actually reside in the same city or municipality. However, there are exceptions to this rule where there is no requirement for the filing to the lupon. Okay? What are these exceptions? Number one, there is no private offended party. Number two, one of the parties the government or any subdivision thereof. One of the parties is a public officer employee and the dispute relates to the performance of his official functions. Or the parties reside in different cities or municipalities. Or the accused is already under police custody or detention. Alright? Let's go to those crimes that cannot be prosecuted de officio. As a rule, a complaint or information may only be filed or dismissed if there is prior written authority or approval of the provincial or city prosecutor or the chief state prosecutor, the ombudsman or his deputy as the case may be. However, class, there are exceptions to this rule, and these exceptions are those crimes which cannot be prosecuted de officio. What does this mean? Okay? This simply means that there are particular crimes where only specific persons may file it. Okay? And what are these crimes? These crimes that cannot be prosecuted de officio. One, the first one is adultery. Second one, concubinage. Third, seduction. Fourth, abduction. Fifth, acts of lasciviousness. And sixth is defamation. Defamation involving the crimes that I have said earlier. Okay? Now, what is the reason for this? What is the reason why these crimes cannot be prosecuted de officio? And the reason is this was imposed out of consideration for the aggrieved party, who might prefer to suffer the outrage in silence rather than go through with the scandal of a public trial. Now, let's go specifically to adultery and concubinage. Who can file it? Can file it. It's only the offended spouse. In seduction, abduction, and acts of lasciviousness, who can file? There are several. Okay? However, these are successive. Okay? Now, number one, as to who can file? Minors. Even independently of those that I would mention, except if the minor is incompetent or incapable. Okay? Second, the parents, grandparents, and guardian. Okay? The right to file shall be exclusive of all other persons and shall be exercised successively in this order. Okay? And last one is the state. Only if the offended party dies or becomes incapacitated before he or she can file the complaint and he or she has no known parents, grandparents, or guardian. How about the last one, defamation, which consists of the imputation of the offenses that I just mentioned. Who may file? It is the offended party. Okay. Now, in adultery and concubinage, you have to remember that in filing it, it must include both guilty parties if both are alive. Okay? Second, it must not, or the private offended spouse must not have consented to the offense or pardoned the offenders. And lastly, the marital relationship must still be subsisting. Okay? Now, in relation thereto, let us discuss the implications of a pardon by the offended party. Now, as a general rule, a pardon by the offended party does not extinguish criminal action, but only the civil liability ex delicto or arising from the crime, or the civil liability with regard to the interest of the injured party. It's the only one that is extinguished. As a general rule, again, a pardon by the offended party does not extinguish criminal liability. However, there is an exception. Okay, in seduction, abduction, and acts of lasciviousness shall not be prosecuted if the offender has been expressly pardoned by the offended party or her parents, grandparents, or guardians. Now, when should a pardon be done? In this case, as a general rule, the pardon must be done before the filing of the criminal complaint in court. Before the filing of the criminal complaint in court. After the complaint has been criminal complaint or information has been filed in court, okay, pardon is no longer effective by the offended party to extinguish criminal liability in cases or in crimes that I have just mentioned. However, there is an exception to this rule. In cases of rape, marriage between the offender and the offended party would be effective as a pardon even when the offender has already commenced serving his sentence. Okay. Now, let's discuss certain events or occurrences that may have happened after the filing of the case in court. You file the case in court, or the case has already been filed in court, and something happens. Now, okay, what happens if the offended party dies? Okay, the death after filing of the complaint or information would not deprive the court of jurisdiction. The death of the offended party in private crimes is essential solely for the initiation of the action. Okay? Once the complaint or information has already been filed in court, the death of the offended party is immaterial, even in the offenses classified as those which cannot be prosecuted de officio. Okay? Precisely, the death of the offended party is not one of the causes for the extinguishment of criminal liability as enumerated in Article 89 of the RPC. Okay? Now, what happens if the offended party desists? There is a desistance, affidavit of desistance from the offended party. Okay? What happens then? Would the criminal case be extinguished? The answer is no. The answer is no. Okay? Desistance does not bar the state from prosecuting the criminal action. However, it would constitute as a waiver of the right to pursue civil indemnity. Okay? It constitutes as a waiver of the right of the private offended party executing the desistance to pursue civil indemnity. Question class. Can criminal prosecutions be enjoined? Okay? Can it be enjoined? Okay? Can injunction be issued to restrain criminal prosecution? As a rule, class, criminal prosecution may not be blocked by any court prohibition or injunction. What is the reason? Okay? Because public interest requires that criminal acts be immediately investigated and prosecuted for the protection of society. However, there are several exceptions to this rule as enunciated in the Supreme Court in several cases. Some of these exceptions are to afford adequate protection to the constitutional rights of the accused. Second, for the orderly administration of justice. To avoid oppression or multiplicity of suits where there is a prejudicial question. Okay? Where the acts of the officer are without or in excess of authority. Okay? And others. Okay. Alright? Question class. Who controls the prosecution of a case? Of course, obviously, it is the public prosecutor. Because as a rule, all criminal actions commenced by a complaint or information shall be prosecuted under the direction and control of the prosecutor. Okay? Another query class. Can a private prosecutor prosecute a case? Okay? Is it possible? Yes, it is possible. A private prosecutor may be authorized in writing by the chief of the prosecution office or by the regional state prosecutor to prosecute the case subject to the approval of the court. However, there are conditions for a private prosecutor to prosecute a criminal action. And these are: first, the public prosecutor has heavy work schedule or there is no public prosecutor assigned in the province or the city. The private prosecutor is authorized in writing by the chief of the prosecutor office or the regional state prosecutor. Third, the authority of the private prosecutor was approved by the court. Fourth, the private prosecutor shall continue to prosecute the case up to the end of the trial unless the authority is revoked or otherwise withdrawn. And lastly, in case of a withdrawal or revocation of the authority, the same must be approved by the court. However, class, take note that the prosecution for the civil liability has not yet been reserved or waived. Okay? If the prosecution of the or if the civil liability has already been reserved or waived by the private offended party, then the private prosecutor can no longer prosecute the case. Alright? However, class, you must remember that once a complaint or information has already been filed in court, any disposition of the case, as its dismissal or the conviction or acquittal of the accused, rests on the sound discretion of the court. Thereafter, a motion to dismiss should be filed with the court, which has the option to grant or deny it. Okay?
Alright, class, let's proceed with the specific discussion on complaint or information. Now let us define what is a complaint. Let us also define what is an information. Now, a complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. In contrast, an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Now, if you will be asked to distinguish between a complaint and an information, you go to the definition that I just mentioned. And from that definition, we can see or we can determine the distinctions between the two. The first distinction is as to who subscribes. Who subscribes the complaint and who subscribes the information. Now, who subscribes the complaint? It may either be the offended party, any peace officer, or other officer charged with the enforcement of the law violated. On the other hand, the information must only be subscribed by the prosecutor, and this is an indispensable requirement. Okay? Where do you file it? Where do you file the complaint and where do you file the information? Now, the complaint is filed in court or the prosecutor's office. It depends on whether or not the place where the crime was committed is a chartered city. Okay? Now, information. Where do you file it? You file the information always in the trial courts or file it with the court. Okay? Now, as to the oath requirement. In a complaint, it is required to be under oath. It's required to be subscribed and sworn to a proper officer authorized to administer oaths. However, in an information, it need not be under oath. Why? Why is that? Because the fiscal, in filing the information, is acting under the oath of his office. However, class, take note. The complaint being described here is not the same complaint or is not the same affidavit complaint you would file in the public prosecutor's office or in the prosecutor's office, okay, for purposes of preliminary investigation. This complaint is that filed with either with the MPC or with the prosecutor if no preliminary investigation is required. Okay? That's clear. Okay. Now, let us proceed to the requirements for the validity of an information or a complaint. Now, what must be included in the information or the complaint in order for it to be valid? Okay? First, it must contain the name and surname of the accused or any appellation or nickname by which he or she is known or had been known. Second, the designation of the offense given by statute. Third, the acts or omissions complained of as constituting the offense. Fourth, the name of the offended party. Fifth, the approximate date of the commission of the offense. Take note, class, the approximate date. It does not need to be exact. And lastly, the place where the offense was committed. This is a very important requirement because, as I have discussed, venue in criminal cases is jurisdictional. It's very important. Now, what is the form required for the validity of the complaint or information? It must be in writing. There is no oral complaint. There is no oral information. Second, it must be in the name of the people of the Philippines. Why? Because it is the state which prosecutes. It is the state which is the offended party. Okay? And lastly, it must be against all persons responsible for the offense involved. Okay? Now, question class. Can the defect in the complaint or information, may it be waived? The defect in the information or complaint, may it be waived? Okay, what do you think? Yes, as a general rule, an accused is deemed to have waived his right to assail the sufficiency of the information when he voluntarily entered a plea during arraignment and participated in the trial. So you have to raise your objection prior to arraignment, prior to you pleading guilty or not guilty. Okay? However, by way of exception, when the defect consists in the lack of authority of the prosecutor who filed the information, such defect is jurisdictional. Therefore, it cannot be waived in accordance with Rule 117, Section 9. Also, in my opinion, class, if the defect consists in the place of the commission of the offense, okay, if the place was not properly included in the information or the complaint, it cannot be waived. Why? Again, because venue in criminal cases is jurisdictional. Alright, let's proceed to the specific requirements of the validity of a complaint or information. What did we mention earlier? Number one, the name of the accused. Now, with respect to the requirement of the name of the accused, the complaint or information must state the name and surname of the accused or any appellation or nickname by which he or she has been or is known. Okay, class? If known. If you know the name of the accused, if it can be ascertained. However, class, if his or her name cannot be ascertained, he or she, the accused, must be described under a fictitious name with a statement that his true name is unknown. For example, you do not know the name of the accused, the perpetrator of the alleged crime. You just state there John Doe. Or if it is a woman, Jane Doe. Okay? Or any other fictitious name that you can think of. Also, class, take note that if the true name of the accused is thereafter disclosed by him or appears in some other manner to the court, such name shall be inserted in the complaint or information and record. So, kung makabalo na sila thereafter sa pangalan sa accused, okay, the name would be substituted to the fictitious name or the nickname, okay, as provided in Section 7, Rule 110 of the Revised Rules on Criminal Procedure. Now, what happens if there is a mistake in the name of the accused? Does it necessarily entail that there is a mistake as to the identity of the accused? The answer is no. The answer is no. Mistake in the name of the accused does not necessarily amount to the mistake in the identity of the accused, especially when sufficient evidence is adduced to show that the accused is pointed to as one of the perpetrators of the crime. If he is positively identified by one witness, his name or a mistake in his name cannot be equated with a mistake to his identity. Alright? Now let's go to the requirement of the name of the offended party. Alright? Let's proceed to the requirement of the name of the offended party. Under Rule 110, Section 12 of the Revised Rules on Criminal Procedure, the complaint or information must state the name and surname of the person against whom or against whose property the offense was committed, or any appellation or nickname by which such person has been or is known. If there is no better way of identifying the offended party, he or she must be described under a fictitious name. Now, take note, class, in crimes against property, if the name of the offended party is unknown, the property itself must be described with such particularity as to properly identify the offense charged, if it is crimes against property, class. Okay? And if the true name of the person against whom or against whose property the offense was committed is thereafter disclosed or ascertained, the court must cause such true name to be inserted in the complaint or information and the record. Okay? Pareha ganila. Alright? And lastly, if the offended party is a juridical person, say corporation, okay, it is sufficient to state its name or any name or designation by which it is known or may be identified without need of averring that it is a juridical person. Okay, that's clear, class. That is very simple and that is clear. Now let's go to the requirement of date of commission of the offense. Now class, you must remember that as a rule, it is not necessary to state the exact precise date that the offense was committed. Okay? The offense may be alleged to have been committed on a date as near as possible to the actual date of the commission. Okay? It must be an approximate date only, class. Pwede approximate lang, not exact. However, by way of exception, if the date itself is an essential element of the crime, then the date must be the exact date. Okay? For example, abortion or bigamy. Okay, bigamy. Okay. Why? Nga naman kailangan nag-date? Okay? Because you have to determine at the time of marriage, he was not married. Okay? He was not previously married. There is no previously valid marriage. Alright? Now, question. What if there is a variance in the alleged date, in the date alleged in the complaint in information and that proven in trial? Okay? What if there is a difference? Now, as a general rule, allegations in an information of a date different from the one established during trial is not fatal to the prosecution, class. Okay? It is just deemed supplanted by evidence presented during trial or may even be corrected by a formal amendment of the information. However, by way of exception, it is fatal when the discrepancy is so great, like 5 years apart, that it induces the perception that the information and the evidence presented in trial are no longer pertaining to one and the same offense. Okay? Now, alright, let's proceed to the place of commission. Okay? Under Rule 110, Section 10, the information or complaint is sufficient if it can be understood from its allegations that the offense was committed or some of its essential ingredients occurred at some place within the jurisdiction of the court. However, by way of exception, if the particular place where it was committed constitutes an essential element of the offense charged or is necessary for its identification. Alright, that's very simple, class. Iingon ninyo asa nahitabo ang offense or crime. Okay? It must be stated in the complaint or information. Now let's go to the designation of the offense. The first part of Section 8, Rule 110 provides that the designation of the offense given by statute must be stated in the complaint or information. Alright? Now, what happens if there is a variance between the designation of the offense, some designation of the offense, sir? Kana murder. Tayo mo, accused of murder, homicide, robbery, theft, malicious mischief ba? Okay, that is the designation of the offense given by statute or violation of article, etc. Article 247, violation of article as provided in the revised penal code. However, a question may be posed. If there is variance, if there is a distinction, a difference between the designation of the offense and the acts or omissions as stated in the complaint or information, which should prevail? Okay? The facts or the allegations, the acts or omissions alleged and not its title determine the nature of the crime. The designation is only the prosecutor's conclusion, class. So which prevails? The acts or omissions alleged. Okay? Alright, let's go to cause of the accusation. Okay, it's Rule 110, Section 9. Also provides that the acts or omissions complained of as constituting the offense and the qualifying and aggravating circumstances must likewise be stated. How do you state this? Do you have to state it in the language used in the statute? No. No, there is no requirement that it be stated in the same language used in statute. What is the requirement is that it is stated in ordinary and concise language, in terms or in a language sufficient to enable a person of common understanding to know what offense he or she is being charged with, as well as its qualifying or aggravating circumstances. Now, class, a question may be posed. Now, what is the purpose of requiring the allegation of each and every element in the information or complaint? There are several purposes to this. The first one is that to enable the court to pronounce proper judgment. Second, to furnish the accused with information as to enable him to make a defense. Siyempre, kung wala nakabutang sa information or complaint, kung saan niya pagdepensa siyang sarili. And thirdly, as a protection against further prosecution for the same cause. Okay, now class, question. What if na ay matters dito, na ay acts or omissions na wala nabutang sa complaint or information, and it was subsequently proven during trial? Okay? Would the accused be convicted of these elements, or would these elements be appreciated by the court? What is the answer? The answer is no. No. Okay, class? Even a plea of guilty will not cure such a defect nor justify such a conclusion. Why? Why? Nga naman, because it would violate the right of the accused to due process. Precisely, kung wala na butang, kung saan niya pagdepensa. Okay? He was deprived of his right to due process and deprived of his right to be informed of the charges against him. Okay? Question, another question. What if the complaint or information did not mention any qualifying or aggravating circumstances in the complaint or information? Okay? There were no allegations of any qualifying and aggravating circumstances. However, it was subsequently proven during trial. What happens? Okay? Would those circumstances, the qualifying and aggravating circumstances, be appreciated in the decision of the court? Would it? No, it would not. Okay? They are not to be considered even if proven during trial. Now again, by way of review, if the aggravating circumstances and qualifying circumstances were not alleged, they cannot be appreciated, class, even if it is proven during trial. For example, ang nakabutang dito sa complaint or information, gidunggab lang siya, na nakaatubang, nakabantay siya, so that is homicide. Pero pag abot sa trial, na-prove day na wa siya kabantay, nikalit na gawas, gitunggab sa likod, that would qualify the crime to murder because of the presence of treachery. Okay? If that is the case, he cannot be convicted of murder because it was not alleged in the complaint or information. Okay? Klaro na, klasa? That is clear. Okay. Again, the failure to allege such in the information or complaint cannot be cured by an amendment of the information after the accused has entered this plea. Again, class, if the qualifying or aggravating circumstances was not included in the complaint or information, and the accused entered this plea, such a defect in the complaint or information cannot be cured by a subsequent amendment of the information or complaint. Okay? Now, relevant in our discussion in the sufficiency of the complaint or information is the concept of duplicity of the offense. What is it? What is this duplicity of the offense? Okay? It simply means, class, that in an information, this duplicity of the offense is the joinder of two or more separate and distinct offenses in one and the same information or complaint. Daghang crimes gibutang sa isa ka information pag file sa court. Okay. Is that allowed? No, that is not allowed because the rules on criminal procedure expressly provide that a complaint or information must charge only one offense. Okay, class A? It must charge only one offense. Okay? However, there is an exception to that rule. Okay? Multiple offenses may be charged when the law prescribes a single punishment for various offenses as provided in Rule 110, Section 13. Now, somebody na, sir, na kanang multiple offenses and a single punishment. If you can remember from your criminal law, complex crimes, okay? Special complex crimes, continuous crimes, okay? Crimes susceptible of being committed in various modes, okay? Now, what are the examples of complex crimes? Acts committed in furtherance of rebellion and absorbed in a single crime of rebellion, etc., etc. Special complex crimes, continuous crimes. These are the exceptions where you may include several crimes or offenses in one complaint or information. Now, if the complaint or information alleges several crimes or offenses and it is not within the ambit of the exceptions I just mentioned, what would be the remedy? What would be the remedy of the accused? The accused would move for the quashal of the information. Again, class, move for the quashal before arraignment. Because your objections to duplicity of the offense in the information filed before the court is waivable. Therefore, if you do not exercise or if you do not move for the quashal of a duplicitous complaint or information before arraignment, it is deemed waived. Okay? Alright, class, let's proceed to amendment or substitution of a complaint or information. Now, before we proceed, it would be perhaps prudent to define what is amendment and what is substitution. Something amendment, something substitution. Okay? Under Tihanki Jr. versus Madaya, GR number 103102, 1992, the Supreme Court had the opportunity to define what is an amendment. And an amendment is a change in either the form or substance of the same offense in the information. It is not a new charge. It just supersedes the original information but relates back to the date at which the original information was filed. Okay? Now, relevant to our discussion in amendment of a complaint or information are the kinds of amendment. Now, what then are the kinds of amendment? We have two. Formal amendment and substantial amendment. Okay, how do we define a formal amendment? A formal amendment merely states with additional precision something which is already contained in the original information and which, therefore, adds nothing essential for conviction for the crime charged. On the other hand, a substantial amendment consists of the recital of facts constituting the offense charged and determinative of the jurisdiction of the court. Okay? So it changes the defense, theory of the defense of the accused if it is a substantial amendment. Now, when should this amendment be made? When should it be made? Kanus man ka pwede maka-amend sa complaint or information. Actually, you can make your amendment before your plea or before arraignment and also after your plea or arraignment. Now, the rules are different. If you move for the amendment of the complaint or information before or after the plea. Now, as a general rule, any formal or substantial amendment made before the accused enters plea may be done without leave of court. Klaro ni klasa? Formal or substantial amendment, pwede nimo na buhaton without leave of court if it is prior to the arraignment, if it is prior to the accused making his plea. Okay? However, by way of exception, if the amendment downgrades the nature of the offense charged or excludes any accused from the complaint or information, the amendment can only be made provided, first, it is upon motion of the prosecutor. Second, it is with notice to the offended party. And third, it is with leave of court. Sa may leave of court, sir? Sa man siya? Leave of court, mao ni siya imong ginahatag sa korte para mananghid ka ba? By way of motion, you move for the court to allow you to amend the complaint or information. Okay? So clear class, ha? It's very clear. Any formal or substantial amendment, yes, even substantial amendments are allowed to be made even without leave of court if it is prior to arraignment or prior to the accused entering his plea. However, a question may be asked, what if the accused has already pleaded, sir, not guilty, or he has already been arraigned? Can amendments still be possible? Yes, class, yes. However, the answer calls for a distinction. What then do we distinguish? We distinguish as to whether or not the amendment is a formal amendment or a substantial amendment. If it is a formal amendment, it can be done provided it is made under two conditions. This with leave of court, and it does not prejudice the rights of the accused, as provided in Section 14, Rule 110 of the Revised Rules on Criminal Procedure. Kung substantial amendment ba, sir, pwede. No, it cannot be done. Okay? Cannot be done. A substantial amendment after the accused has made his plea or has entered his plea is proscribed, class. Why? What is the reason? Because it violates the right of the accused to be informed of the nature and cause of the accusation during his plea. Ingnan man kaana, pag i-arraign ka, ngano ka gikiha, ngano ka gipailag kaso. Okay? However, by way of exception, class, by way of exception, even if it is a substantial amendment, if the amendment is beneficial to the accused, it may be allowed. Okay, as provided in People versus Janeiro, GR number 129254, a 2007 case. Okay. Now, relevant to this discussion is, how do we determine then? What is the test then to determine whether or not an amendment is formal or if it is substantial? Okay? This is the test. Whether or not a defense under the original information would be equally available after the amendment, and whether or not any evidence the accused might have would be equally applicable in one form as in the other. Okay, if the answer is yes, then it is a formal amendment. If the answer is no, it is a substantial amendment. Alright? Let's go to substitution of the information. Class, you have to distinguish between substitution and amendment, class. These are two different concepts. Alright? What does the rules of court say about substitution of information? Alright, let us consult Rule 119, Section 19 of the Revised Rules on Criminal Procedure. It provides, when it becomes manifest at any time before judgment that a mistake has been made in charging the proper offense, and the accused cannot be convicted of the offense charged or any other offense necessarily included therein, the accused shall not be discharged if there appears good cause to detain him. In such a case, the court shall commit the accused to answer for the proper offense and dismiss the original case upon filing of the proper information. Now, class, what happens in substitution? The original charge is dismissed and there is a new offense that is substituted in lieu of the original one. Alright? Now, what are the limitations of such a substitution of information? Rule 1110, Sections 14, 19 provides that it must be made, the substitution must be made at any time before judgment has been rendered. Second, the accused cannot be convicted of the offense charged or any other offense necessarily included therein. Now, what does this mean? It means that the offense in the substituted information involves a different offense which does not include those provided in the original charge. Alright? And lastly, the last limitation for the substitution of an information is that the accused would not be placed in double jeopardy. Alright? Because substitution presupposes that the new information involves a different offense which does not include or is not included in the original charge. Okay, now, pertinent to our discussion is the distinction between amendment and substitution. Alright? With respect to scope, the amendment covers formal or substantial changes, while substitution involves only substantial changes. The change in substitution is always substantial because there is a different offense. You substitute a different offense from the original one. Now, with respect to applicability or the necessity of a leave of court, in amendment, if it has been made before the plea has been entered, it can be effected without leave of court. However, in substitution, it must always be with leave of court. Okay? Now, another distinction, whether or not a new preliminary investigation is required. In amendments, when the amendment is only as to the form, there is no need for the taking of another PI or for the retaking of the plea, the arraignment. However, if it is a substitution, you substitute a new offense, another PI or preliminary investigation is required, and the accused has to plead anew. Alright? Now let us proceed to venue of criminal actions. What is venue again? Where the crime or any of its essential ingredients has been committed. Okay. Now you have to remember, class, that venue in criminal cases is jurisdictional. Okay. In all criminal prosecutions, the action must be instituted and tried in the courts of the municipality or territory where, number one, again, by way of review, where the offense was committed, and second, any of its essential ingredients occurred. Okay? That is the general rule. However, by way of exception, we have exceptions to this rule. Okay? Our first exception are those felonies under Article 2 of the Revised Penal Code. You remember? If you don't, you read it again. Now, where is the venue for those felonies under Article 2 of the Revised Penal Code? Rule 110, Section 15 provides that the venue is the proper court where the criminal action was first filed. Okay. How about those crimes committed on a railroad, a train, a railroad train, an aircraft, or any other public or private vehicle in the course of its trip? Where is the venue there in criminal actions? The venue is in the court of any municipality or territory where such train, aircraft, or other vehicle passed during its trip, including the place of departure and arrival. Alright? How about those crimes committed on board a vessel in the course of its voyage? Where's the venue in that case? The venue is in the proper court of the first port of entry or of any municipality or territory through which such vessel passed during its voyage. Okay? However, this is subject to the generally accepted principles of international law. What if the crime committed was piracy? Piracy, if you can remember, has no territorial limit. So where is the venue? Okay? The venue is anywhere. It may be instituted anywhere, as provided in the landmark case of People versus Lolo and Sarao, a 1922 case. Okay? How about libel? Libel. If the crime is libel, where is the venue? Okay? Must distinguish. The question calls for a distinction. Now, if the offended party or one of the offended parties is a private individual, the venue of the crime of libel is, first, where the libelous article is printed and first published, or where said individual actually resides. Okay? If one of the offended parties or the offended party is a public official, not a private citizen, a public official, the venue for the crime of libel is where the official holds office at the time of the commission of the offense. And if the office is in Manila, then must be in the courts in Manila. If the office is any other city or province, then file where he holds office. Or where the libelous article is printed and first published. Okay. How about those bouncing checks? BP22, violation of pambansang bilang number 22. Where should it be filed? Where is the venue? Okay? It may be filed, or the criminal case for violation of BP22 may be filed in the place where the check was dishonored. Okay, number 1, the place where the check was dishonored. Or second, in the case of a cross-check, in the place of the depository or collecting bank. Okay. How about cases of illegal recruitment? Now, the victim, it is the victim, was the option to file the case in his place of residence, in the place of residence of the victim, or in the place where the crime was committed. Alright? Now, how about those transitory or continuing offenses? Where is the venue there? Okay? Or where is the venue in those types of crimes, in those types of offenses? Okay? Jurisprudence provides that the venue for transitory or continuing offenses or crimes are the courts of the territories where the essential ingredients of the crime took place have concurrent jurisdiction. Again, the courts of the territories where the essential ingredients of the crime took place have concurrent jurisdiction. Kung concurrent jurisdiction sila, kinsa may makakuha ang jurisdiction diha. Okay? The first court taking cognizance of the case will exclude the others. Alright?